After watching my one video on anticipatory bail, I was suggested to make one video as far as bailable and non-bailable warrant is concerned. Bailable and non-bailable warrant and some cases in this regard. So friends, today I am going to make this video. The topic is bailable and non-bailable warrant. I hope you enjoy this video. Let me begin this video as far as this topic is concerned. So 3 steps: hard, harder and hardest. Summons, bailable warrant and NBW, that is non-bailable warrant. Provisions are mentioned in CRPC as far as chapter 6 is concerned. For the requirement of the person being present in the court, these 3 steps are required to be taken by the concerned courts or court. Now the question arises whether any necessary steps should be taken before issuing warrants by the court, or under which circumstances or when Chief Judicial Magistrate or Magistrate First Class can issue warrant to any person. There are some reasons or there are some cases or circumstances. First step or first circumstances: 1. If the person is escaped convict. If the person is escaped convict. 2nd, if he is proclaimed offender. 3rd, if the person is an accused of non-bailable offence. 4th, he is evading arrest as mentioned in section 73 subclause 1 of CRPC. These are the grounds under which a warrant can be issued to the person. Now, I am also suggested to discuss some case in this regard. Omvati versus State of Uttar Pradesh and another. Now, this is very interesting case because Omvati is not at all an accused. She was complainant, challenging the order of district court. She filed an appeal before Honorable High Court. In district court, the respondent before Honorable Supreme Court, that is the main accused, was acquitted. That is why she filed an appeal. However, due to any reasons or in a very routine manner, Honorable High Court passed an order for issuing warrant. First bailable, then non-bailable. See the scenario. What would be the situation if in a routine manner or in a mechanically manner if the warrant is issued? This lady was complainant in the original case. Before Honorable Supreme Court, she was appellant. Honorable Supreme Court observed all these things in para number 6 of the judgment and compensated to the lady that mechanically or in a routine manner this order of issuing bailable or non-bailable warrant was there, and that is why that order was set aside by Honorable Supreme Court. How and when warrant should be issued by the court, or under which circumstances should the court issue the warrant? This answer is given by Honorable Supreme Court in one of the important cases. The name of the case is Inder Mohan Goswami versus State of Uttaranchal, 2007, 12 SCC 1, a bench of 3 judges, wherein entire discussion is based on issuing of warrant and what are the consequences thereon. Now let me discuss this judgment, para number 51 of the judgment. The courts have to be extremely careful before issuing NBW, non-bailable warrant. The court should be extremely careful. What are the reasons for that? A. The issuance of non-bailable warrant involves interference with personal liberty. 1. B. Precious right of personal liberty is deprived by arrest and imprisonment. Here in this paragraph, Honorable Supreme Court emphasizes as far as personal liberty of the person is concerned, that is envisaged in Article 21 of the Constitution of India. Now, para number 52. Personal liberty and interest of society both should be maintained and equally important for the survival of a civilized society. Sometimes in the larger interest of public and state, when it becomes absolutely necessary or imperative to curtail freedom of an individual for a certain period, only then non-bailable warrants should be issued. Here in this paragraph, Honorable Supreme Court guided us that under which circumstances non-bailable warrant should be issued. Now, when non-bailable warrant should be issued, even it is further discussed in para number 53. Para number 53, when to bring a person to court, summons or bailable warrants are not sufficient enough to get the desired result. Non-bailable warrant should be issued. Second point, when it is reasonable to believe that the person will not voluntarily appear in the court, or the police authorities are unable to find the person to serve him with a summon, or it is considered that a person could harm someone if not placed into custody immediately. These are the grounds mentioned by Honorable Supreme Court in para number 53 of this judgment, that under such circumstances non-bailable warrant should be issued. Further, para number 54. Para number 54 says that if the appearance of the accused is made by issuing summons or bailable warrant, the court should never issue warrant, bailable or non-bailable, without proper scrutiny of facts and complete application of mind. The court must very carefully examine that the criminal complaint or FIR has not been filed with malafide intention or oblique motive. Now the question is, what should be done in complaint cases? The answer is given by Honorable Supreme Court in para number 55 of the judgment, which says that in complaint cases the court should issue first summons. If by summons the accused is not willing to come or willing to attend the court, then the second chance is for bailable warrant. And even from bailable warrant, the accused is not willing to be before honorable court, then the third chance is non-bailable warrant. But it should be very, very much sure that the accused person has avoided the process intentionally and voluntarily. The non-bailable warrant should be then and then issued. Reason? Again, personal liberty of a person, and therefore courts are advised to avoid issuance of NBW. First and second points. First, summons, second, bailable warrant, and third, non-bailable warrant. Now, when issuance of non-bailable warrant should be avoided, the answer is given in para number 56 of the judgment, wherein Honorable Supreme Court directed that court should properly balance both personal liberty and interest of society before issuing warrants. If it is observed by Supreme Court that there is no straitjacket formula, Honorable Supreme Court observes here that there is no straitjacket formula for issuing warrants. But as a general rule, if an accused is not charged with the commission of an offense of heinous crime, if an accused is not charged with the commission of a heinous crime, and if it is not feared of tampering or destroying evidence by the accused, or is not likely to evade the process of law, issuance of NBW should be avoided. Whenever there is no circumstances, whenever there is no fear, or whenever there is no chance of tampering or destroying the evidence from accused side, NBW is not required to be issued. This is what Honorable Supreme Court said. Now, in para number 57, the court should try to maintain proper balance between personal liberty, individual liberty, and interest of public and state while issuing non-bailable warrant. This is what Honorable Supreme Court has guided us as far as this judgment is concerned in respect of issuing and non-issuing of NBW. Another case as far as non-bailable warrant is concerned, or issuance of non-bailable warrant is concerned, another case is of Honorable Supreme Court, which is Raghuvansh Divachan Bashin versus State of Maharashtra 2012 9 SCC 791, para number 10, wherein Honorable Supreme Court says that NBW cannot be issued mechanically. It cannot be issued mechanically, as there is a sole question of personal liberty of a person as far as Article 21 of the Constitution of India is concerned. The courts have to be more careful while issuing NBW. Otherwise, there is a violation or denial of mandate envisaged in Article 21. Now, in para number 11, Honorable Supreme Court observed that power of court for issuing warrant has to be exercised judicially and not arbitrarily. As far as the case of serious offense, past conduct of the accused, his age and possibility of absconding are concerned. In para number 12 of the judgment, Inder Mohan judgment is referred by Honorable Supreme Court. And the most important paragraph of this judgment is 28. 28.1 to 28.12, wherein Honorable Supreme Court has guided us when or under which circumstances the court has to issue the warrant and has not issued the warrant, and it is just like a checklist or the direction. Let me discuss the entire paragraph. Para number 28.1. Para number 28.1 says that all the High Court shall ensure that subordinate courts used printed and machines numbered Form 2 for issuing warrant of arrest, and each such form is duly accounted for. 28.2 Before authenticating, the court must ensure that complete particulars of the cases are mentioned on the warrant. 28.3 The presiding judge of the court or the responsible officer specially authorized for the purpose of the case in case of high courts issuing the warrant should put his full and legible signatures on the process, also ensuring that seal bearing complete particulars of the court is prominently enclosed thereon. Para 28.4 The court must ensure that warrant is directed to a particular police officer or authority, and unless intended to be open-ended, it must be returnable whether executed or unexecuted on or before the date specified therein. Para 28.5 Every court must maintain a register in which each warrant of arrest issued must be entered chronologically and the serial number of such entry reflected on the top right hand of the process. Para 28.6 No warrant of arrest shall be issued without being entered in the register mentioned above, and the court concerned shall periodically check or monitor the same to confirm that every such process is always written to the court with due report and placed on the record of the case concerned. Para number 28.7 A register similar to one in para number 28.5 shall be mentioned at the police station concerned. The station house officer of the police station concerned shall ensure that each warrant of arrest issued by the court, when received, is duly entered in the said register and is normally entrusted to a responsible officer for execution. Para number 28.8 Ordinarily, the courts should not give a long time for return or execution of warrants, as experience has shown that warrants are prone to misuse if they remain in control of executing agencies for long. Para number 28.9 On the date fixed for return of the warrant, the court must insist upon a compliance report on the action taken thereon by the station officer or of the public station police station concerned. Para number 28.10 The report on such warrants must be clear, cogent and legible, and duly forwarded by a superior police officer so as to facilitate fixing of responsibility in case of misuse. Para number 28.11 In the event of warrant for execution beyond jurisdiction of the court issuing it, procedure laid down in sections 78 and 79 of the code, that is CRPC, must be strictly followed. As far as para number 28.12 8.12 is concerned, in the event of cancellation of arrest warrant by the court, the order cancelling warrant shall be recorded in the case file and register maintained. A copy thereof should be sent to the authority concerned, requiring the process to be returned unexecuted forthwith. The date of receipt of unexecuted warrant will be entered in the aforesaid registers. A copy of such warrant shall also be supplied to the accused. These are the guidelines mentioned in para number 28 of the case as far as issuing of warrant is concerned. Vikas versus State of Rajasthan, Honorable Supreme Court says in respect of issuing of non-bailable warrant. In para number 12, Honorable Supreme Court has discussed one provision of CRPC, that is section 319 of CRPC. A person may be arrested or summoned as the circumstances of the case may require, if it appears from the evidence that any such person, not being the accused, has committed of an offence for which such person could be tried together with the already arraigned accused person. Meaning thereby the person who is not an accused in the particular case, but at the time of evidence once come to know that one another person is also involved in the case, then under such circumstances section or the provision 319 of CRPC is applicable, an application is filed. But at that time what is required to be considered by Honorable Court is not to issue NBW directly to the person who is not an accused. This is what Honorable Supreme Court says. Now in para number 14, Honorable Supreme Court has relied upon the earlier judgment of Inder Mohan and Raghuvans, and the court is in all circumstances should first prefer issuing summons and bailable warrant, failing which a non-bailable warrant should be issued. This is the direction given by Honorable Court in para number 18 of the judgment. Relying upon the judgment of Honorable Supreme Court in the case of Inder Mohan and Raghuvans, Honorable Gujarat High Court in the year 2009 in the case Afzanaben Ilyas by Vohra versus State of Gujarat passed an order to convert NBW into an order of issuance a bailable warrant. Very recently, Honorable Jharkhand High Court has decided the issue of non-bailable warrant in the case of Mohammad Rustam Elam Ilyas Rustam versus the State of Jharkhand, CRMP number 2722 of 2019, which is decided on 27th April 2020, wherein Honorable High Court has also referred the two judgments of Honorable Supreme Court in the case of Inder Mohan Goswami and Raghuvans Basin. Please don't forget to subscribe my channel if you like this video. Friends, I appreciate your comments in the comment box. Thank you very much.